Good evening. How you doing? Hello. Good evening.
Evening, everyone.
Hi, Chrissy. I was trying to get your attention, but I guess you weren't on.
Oh, I just walked back in the room.
Oh, okay. How y'all doing?
I'm good.
Okay.
All right. I guess they will join us shortly. You all had a chance to review the information I'd sent.
It's been a very rough week for me, so I have not had a chance.
I briefly review it. I remember that case from when we was doing the certainties of objects.
Okay. Upfield and Dalton?
Yes, ma'am.
Okay, yeah.
Oh.
Okay, so just a little quick overview. What is a trust instrument?
A legal document outlining the general terms of the trust.
Right.
The duties and powers of the trustees.
Say it again.
I was saying there's also the duties and the powers of the trustees.
Right, and what is the significance of that trust instrument? To the trustee, what is the significance of the instrument? That's where he would go for directions, eh? It's similar to the
how to administer the trust.
Right, so it's similar to what in the company?
The letter of wishes?
No, in the company, remember we drew a similarity to it with the company's bylaws compared to the trust. With the trust, right, so we draw that reference so we'd remember what the document is, because it tells them what powers they have, what is the trust corpus, all those things, eh? And how can we incorporate the powers where we may not be specific enough? How can we incorporate that by statute? In the trust instrument, how can we incorporate additional powers that we may not think of initially when we're settling a trust?
You're
How can
talking
we-
about in section 90 of the Trustees Act?
Right, so we can use section 90, and what that allows us to do.
It makes provisions for additional
So what we'll do, incorporate what? The first schedule of the Trustee Act, remember that? Which
Yes.
will give us powers of investment, dispose of and deal with the trust fund. And what it does is it reduces what? The terms of the trust, but it includes important provisions for the proper administration of the trust that we may not think of when we are drafting a trust document, but these provisions will give us a head start or give us an advantage of us with us not leaving something out, right?
Yeah.
What about the trust instrument? What is important to do when we settle the trust? What we should do first as trustees, once we settle it, what we need to do with it?
Stamp it.
Right,
Have
we
it
have to get it stamped, right? How much is the stamp?
$50.
And how do we stamp it?
Get a stamp.
What-
Affix the stamp to the trust document.
And
Register.
no, remember we have to sign, we
Oh,
have to initial it and date it, and that cancels out the stamp, remember? So if the trust company is a domestic company, you usually have 2 directors, a minimum of 2. They would initial it, and then you would put the date on it, and that cancels out the stamp. And now it can now be entered into evidence in civil proceedings, right?
Yes.
What about Smith and Rosewood case? What that helps us with? It goes along with a statute.
beneficiaries rights to information.
Right, so that's the common law and what the statute says, what section that is.
Section 83.
Excellent, excellent. Now, when we, our internal trust communications, how do we show our deliberations of how we came to a decision on distributing?
Say that again.
How do we show our deliberations and come into a decision on distributing trust property or making distribution to beneficiaries? How do we show our deliberations? How is it documented?
In the minutes?
Yes, in the trustee minutes. So are these trustees minutes open to the public or to the beneficiaries?
No,
No.
ma'am.
What documents can we provide to the beneficiaries, and which beneficiaries can we provide these to?
Now, the beneficiaries, they have vested interest.
Right. And what documents we can provide them?
I don't tip my tongue, I can't remember. I gotta look at the book.
I know they can have
documents.
access to the account information, like to
Trust accounts, and what else?
trust account.
And something that we redact.
Oh, I can't remember.
The trust, what?
Deed?
Yes, the trust deed. So we could redact that, but now in certain instances, the court may say we want to show this information. We need to see more than that. When they do, what information, when they ask for this information, why it's important for us to make sure that we have clear and concise information when we do our deliberations, because what happens in this instance? If this document becomes public and it's not clear, or you elaborated, or you have made a misstep, you are now open to what?
Breach?
Yeah, you may be sued for breach of
Trust.
Yes, breach of trust. Because the duty for the trustee to provide information to the beneficiary is a what type of duty?
Fiduciary duty.
Excellent, excellent, excellent. All right, when I'm making up, when I get a letter of wishes, who usually prepares the letter of wishes?
The settler?
Right, and who prepares the memo of wishes? Now the memo is to the file, who could prepare that? Remember, the letter is from the settler. It doesn't have to be signed, eh?
No, ma'am.
Is it a legal document?
No,
Ma'am.
it's only
Okay,
a
the
guide.
memo of wishes is from the trustee, eh? It just is the trustee's outline of what the settler may have said to him, what he wishes to happen, and it's only
Yes,
a guide, eh? Right?
yes, ma'am.
And none of these are legally binding documents, eh?
No, ma'am.
Mhm.
What prohibits, what case tells us that the letter of wishes, the trustees don't have disclosed this to the beneficiaries?
Australian Hartigan nominee PTY Limited versus Ridge.
Right, right. And what section of the Trustee Act gives us that protection as well?
Is that also 83?
That's the right to information and what they need to get, eh? So certain information, right?
Mm-hmm.
So section 83 tells us what the trustee has, the right of the trustee has to give the beneficiaries the information, and under certain specified conditions and in certain specified circumstances. Yes?
Yes.
All right, so I think we can move on to Unit 3. Unit 3 is pretty quick. We'll be out of there in no time. I hope the others join us shortly. But these are pretty much, remember, we only expanded on what we started off with, eh?
And section in the first phase.
Right, in Unit 1.
Mm-hmm.
So we already know, we summarized all of this, and now we expanding on it so we can just open our minds a bit more to what we've learned initially. So after completing this unit, you should be able to understand the trustees' discretionary powers, determine the ambit and extent of trustees' powers. You should learn the fundamentals of the trust committee and appreciate the legal principles underlying the exercise of trustees' powers. Okay, Chriselia, you want to start for us, please?
Yes, ma'am. Discretionary
Thank you.
trust. Discretionary trusts are inter vivos or testamentary trusts, where trustees have discretionary powers regarding which beneficiaries and what entitlements are to be received by beneficiaries in relation to the distribution of trust assets in accordance with the terms of the trust instrument. Such trusts are express trusts, but are not fixed in terms of the beneficiaries and their entitlements to the trust assets, and require trustees to consider and, where necessary, exercise their discretion in the administration of the trust. In a fixed trust, the
Okay,
beneficiaries
so
are
let's just start again. So discretionary trusts are inter vivos, which means it's a living, the person may still be living, or
yes, ma'am.
testamentary, which means it takes place after their death, trust.
Yes, ma'am.
So this is where the trustee has discretionary powers in a trust where a settler would have settled it, but now they've given the trustee some powers over the trust because they don't really want to be seen as still operating the trust. In that instance, they may prepare or what, so the trustee would be guided. What we'll get from that
The letter of wishes.
Excellent. So we get a letter of wishes, so we'll know how and what we should do as a guide, but we're not to follow it blindly, eh?
Yes, ma'am.
Right. So these trusts are express trusts. So they clearly express what is to happen, but they're not fixed because they don't say exactly what beneficiary should get what. It just is expressed that I would like for so-and-so to probably get this in the future or when he reaches a certain age, but it doesn't say definitely give this to so-and-so at this date, okay?
Yes, ma'am.
So, and then it allows the trustee the discretion to decide when and where they're gonna give out this, the entitlements under the trust, okay?
Yes, ma'am.
Go ahead.
Okay. In a fixed trust, the beneficiaries are specifically named and their portion of the trust assets is indefinitely determined. There is no
It is
exercise.
definitively determined.
Yeah.
So in the fixed trust, I say I leave the house that I own to my son, John Doe. And I don't say for the trustee to decide to give him, but I say that is for him. So I've already said that. So I may say for John Doe when he attains the age of 18. So it's still fixed because definitely he should attain the age of 18 unless something unforeseen happens. So I leave it for him for when he attains the age of 18. So I've already taken that house and I've given it to somebody. Okay, so it's fixed. And we know who is it for, and he's gonna be what we'll call him a what? What type of beneficiary he is?
Vested?
Excellent. Yes, he's vested. Because we know what is for him, and when he gets 18, he's vested. Okay?
Yes,
All right, go ahead.
there is no exercise of the trustee's discretion in the administration of a fixed trust. In a discretionary trust, a trustee must select from a class of beneficiaries, and they must distribute the income and the capital of the trust amongst the selected beneficiaries in accordance with the terms of the trust instrument.
Okay, so unlike a discretionary trust, we have the fixed trust, we know what is definitive. The house is for John Doe. In a discretionary trust, it's different because now we may give it to a class of beneficiaries and it may be distributed according to what income and capital may be there. We have that case. What case we know this comes from? What we started off talking about? McPhail and Dalton, remember?
Yes, ma'am.
McPhail and Dalton had a class of beneficiaries who were employees, former employees, or whatever for a certain company.
And their children.
Able to determine there was a class because it only could be an employee, a former employee, or the like, right? So they only would be distributed based on the income or the capital and at the trustee's discretion, eh?
Yes, ma'am.
So that's the difference. The trustee don't have the discretion over when John Doe gets the house. John Doe gets the house at 18. He has no discretion over that. That is John Doe's house. He has the discretion over what he gives you as set out in McPhail and Dalton, eh? So that's the difference there with the fixed and the discretionary trust. So the trustee doesn't exercise the discretion in a fixed trust. Any questions?
No, ma'am.
Okay, let's go.
Constructive trusts and resulting trusts cannot be discretionary trusts, as they arise and are created by operation of law. Whilst discretionary trusts require the assistance of the three certainties: the certainty of intention, certainty of subject matter, and the certainty of objects, and the requisite legal formalities in order to be validly created. Discretionary
Okay, so we
trusts.
know constructive trusts and resulting trusts they arise by and are created by operation of the law. So constructive trusts can be as a matter of what happens when you had the company's property and you used it for your own benefit. Benefit now becomes the benefit of the company because you used your position to gain an advantage. So now the company is the constructive trustee of whatever you would have obtained. Resulting trust happens as a result of whatever you would have had, and it results back into the trust. Okay? So that happened by operation of the law, whereas these are created, these are settled, and it is intentional that these trusts are created. Okay? Okay, let's go.
Discretionary trusts are often created for the following reasons. The settler, to provide for beneficiaries with special financial, mental, and physical needs, to allow flexibility in adapting to changing circumstances of beneficiaries, for the protection of trust assets from wastrel or spendthrift beneficiaries, and to make provisions for a wide range of beneficiaries, including those that may not be born. Trustee, wide powers are usually given.
Okay, so we have for the settler, the discretionary trust in the instance of the settler is created for the settler to provide for beneficiaries who have special financial, mental, and physical needs. So maybe their children or a minor, they want to ensure that they're covered. They want to allow flexibility in adapting to the changing circumstances of beneficiaries. So I may have a child today who's doing well and he may go on drugs. So I want to make sure I've covered him. I've covered what I have for him and protect the assets so that he's covered even if he gets down and out. I wouldn't allow him just to dissipate all of his assets in one go. So I'm still trying to protect him. It's like for succession planning. For the protection of trust assets from wastrels and spendthrifts. So again, spendthrift and wastrel beneficiaries, they may just spend all of their money in one go. They may meet up with someone who may take all of their money from them. So they want to protect them. So if the assets are owned by the trust, you can't put your hands on it so readily because it's now at the discretion of the trustee to give it to you, or to make provisions for a wide range of beneficiaries, including those that may not be born. So I may want to, I want to provide for my grandchild what my daughter has just conceived. I know she's pregnant, and I say, well, I want to even ensure for my grandchild who's in the womb. So I'm looking out for a lot of other beneficiaries, and I want to make provisions that all of them would benefit from my assets. For the discretionary trust, for the trustee, wide powers. So it's given the trustee wide powers to manage the assets of this trust. So that's the benefits why you would create a discretionary trust. Okay, let's go.
To assist in the administration and management of discretionary trusts, settlers often provide letter of wishes, which are not legally binding, which give the trustees pertinent information on the beneficiaries and the settlers' wishes regarding the administration and distribution of the trust assets. The certainty of objects is clearly one of the important certainties in the creation of discretionary trusts, as the administration of such trusts and the exercise of trustees' powers within such trusts require the clear determination of the beneficiaries or class of beneficiaries for whom the trust was created and may benefit. The test for certainty of objects was outlined in McFall versus Dalton and confirmed in Pearson versus IRC. Required that the trustee determine with certainty whether an individual was a member of a class of beneficiaries of a trust. The test also requires that the group of beneficiaries form a distinct group and be administratively workable, i.e., practical to administer the trust in light of the size of the class and the trust assets to be distributed. The fiduciary powers contained in...
Okay, so the test for certainty. So, hello?
Yes, ma'am.
So certainty of objects is certainly one of the important certainties in the creation of discretionary trust. So we should know who are the objects of this trust, who are the persons, the beneficiaries, who this should benefit. The test for certainty is outlined in McPhail and it's confirmed in Pearson. And it requires that one, the trustee be able to determine with certainty whether an individual was a member of a class of beneficiaries of a trust, And it also required that the group of beneficiaries form a distinct group. That means it must be administratively workable. So it cannot be for all my friends, family and friends. That's not administratively workable because we don't know who your friends are. That could be unlimited. And then they may determine friends in a smaller group because they may say only in a social setting and not ones who you do work with. But if you just say family and friends, your family could be never ending. That's not administratively workable, eh? Because family is so broad. You can have cousins, second cousins, and all of them would be considered family, eh? So
Yes,
it
ma'am.
must be administratively workable in light of the size of the class and the trust assets to be distributed. So if you only have $100,000 and you say for all my family and friends, do you think that's administratively workable?
No, ma'am.
So then the trust will fail for certainty of object, you see? So you want to make sure that it falls within the certainty of objects unless the trust will fail because you cannot clearly determine who are the objects of the trust. Okay, go ahead.
The fiduciary powers contained in the trust have within them a duty to consider whether to distribute income or capital. Matoy Pension Trustees Limited versus Evans, but do not require that a trustee actually distribute such capital or income. Turner versus Turner. Trustees are also not required to give reasons to the beneficiaries for the exercise of their discretion. In exercising their powers of discretion, trustees must consider the terms of the trust, the provisions of the law, the expressed intentions and wishes of the settlor, as outlined in the non-legal, legally binding letter of wishes, and the overall management and administration of the trust, including acting in the best interest of the beneficiaries of the trust. The exercise of a trustee's discretion should not be done without conscious thought and actions on the part of the trustee, and should be completed once the facts and merits are evaluated and considered on a case-by-case basis. In other words, any action related to the trust should not occur due to omission on the part of the trustee. It is expected and required that a trustee deliberately and conscientiously exercises his discretion in the administration of the trust. It is important to note that the standard of care that is expected in a professional trustee in the exercise of his discretion is higher than that of the personal trustee acting in his individual capacity.
Okay, so in exercising the powers, the trustee must be conscious about what he's doing. So it shouldn't be as a matter as, oh, that just happened. I should be deliberate in what I'm doing. I should make conscious efforts to ensure that I'm deliberating about what's going on. I've taken into account what I'm supposed to take into account as the trustee, the terms of the trust, the provisions of the law, the express intention and wishes of the settlor, as outlined in the letter of wishes, and the overall management and administration of the trust, while acting in the best interest of the beneficiaries of the trust. So I must take all these things into account before I make a distribution. So when you as a beneficiary come to me, I'm supposed to take all this into account first, and then I deliberate. And based on all of these things, I come to a decision. Now, you as a professional trustee will be held to a higher standard than the person acting as a personal trustee in their individual capacity because you're out there purporting to be somebody with a higher skill and you're supposed to know this area well. So when you're selling yourself off to be this professional, you will be held to a higher standard. So you can't say, well, I didn't know because you out there selling your services. Unlike a personal trustee, where I may have selected a friend and asked them to act as trustee in my will, as well as my executrix and trustee over my minor child. I am not, you don't hold me to any standard because I'm acting as a friend and I'm holding on for you to hold these assets in trust. You have trust that I would do that. The professional trustee is a stranger and you only went to them because they said they can provide the service and they offer the expertise to execute what you need done. Okay?
Wow.
Okay, let's go ahead. Trustee committees. When you finish this page, then we'll let Dominique start for us.
Okay.
Mhm.
Trust committee. Trustees of a discretionary trust will have wide powers and responsibilities. Any decision needed must be made in the best interest of the beneficiary. If a trustee does not exercise his discretion prudently, he may be found in breach of trust of his fiduciary duties of the beneficiaries. Due to the significance of a trustee's exercise of discretion and use of his discretionary powers in accordance with the trust instrument, most professional trustees have trustee committees comprised on three or more trust officers who deliberate and decide on the distribution to be made to beneficiaries of a trust. Without a written record of the decisions taken, there would be no evidence that the trustees exercised their discretion as a result of an active mental process. The trustees must show that they were responsible for actions taken, especially in relation to trust distribution, and the minutes demonstrate this.
So you see why it's so important that they document their deliberations in the minutes, because we need to see that you would have taken what? You have used your discretion in exercising to distribute to any beneficiary who may have asked for some interest to be distributed to him. So you should have a trustee committee, and the trustee committee should consist of 3 or more trust officers who deliberate and decide on the distributions to be made, eh?
That's right.
Any questions?
No.
Okay, let's go. Dominique, thank you, Crasiria.
You're welcome.
Trust committees provide for the overall stewardship and management of trust assets. Their deliberations are often recorded in trust minutes, which outline their review of the relevant trust documents, the requests by the beneficiaries, the reasons for their decisions, and their decisions in the distribution of trust assets. The provisions of most standard trusts with professional trustees require trustees to decide and act jointly in the administration of the trust. The Trustee Act 1998, in recognizing the responsibility of the trustees to act jointly, allows a majority decision to take precedence where there is no clear agreement between the trustees. Although not an exhaustive list, the trust committees often decide the following in relation to the administration of the trust, subject to the terms of the trust. 1. What investments will be made in accordance with the trust instrument and in the best interest of the trust? 2. The distribution of capital or income to a class of beneficiaries or to a named beneficiary. 3. Whether to grant a loan to a beneficiary. 4. Whether to manage special assets. 5. Whether to incorporate a company to hold the assets in the trust. 6. The selection of an investment advisor. 7. The appointment and supervision of agents. 8. Whether to make an advancement to a beneficiary. 9. Whether to mortgage trust property. And 10. Whether to rent trust property and how the rental income will be applied and or distributed.
Okay, so these are some of the things the trustee committee may decide on. This is obviously not a comprehensive or exhaustive list. This is only an idea of what some of the things they may deliberate on. So these are the things they should be considering. So when you come to me as a beneficiary, these are some of the questions you may come asking certain things, and I may say, okay, let me read over this, or let me look over this to see, or I'm supposed to be making decisions for the trust, whether I should mortgage trust property, whether I should rent it out, whether I should make an advancement to the beneficiary, who I'm appointing and how I'm supervising them, how I would select an investment advisor, whether to incorporate a company to hold the trust assets or to manage special assets, whether I'm granting loan to beneficiaries, if I'm going to distribute capital or income to a class of beneficiaries or to named beneficiaries, and what investments, how am I going to invest the trust funds? So these are some of the things that the trustee committee would now take on in deliberating and showing that they made these decisions on behalf of the trust. Okay, any questions?
No.
I have a question. Loan to a beneficiary, like they get borrowed from the trust and they have to pay back?
Yes, they can. So,
Okay.
I mean, it's just like you come into, so you know your parents have money. So this is likewise, your dad settled this trust. And so they may say, I don't, now remember these beneficiaries may not be entitled to $100,000, but he may say, I'm in dire straits. I know the trust provides that we are supposed to get money based on the income or the capital of the trust. However, I need to pay for this, or I'd like to purchase a home. Perhaps I can borrow the money from the trust and have a private mortgage with the trust instead of me going to the bank. And the trust may be in a position to do so. So it's according to, of course, what is available, because they have to, what they have to do in order to make their decision, what all they have to do.
Oh, we have
They
to.
must first consider what? The terms of the trust, the
Yeah.
provisions of the law, the intention and wishes of the settler, the overall management and administration of trust. So if I lend you 100,000 and that will cost the trust to falter, what am I going to be sued for?
Breach?
Yeah, because I mean, you holding yourself out to be a professional, so you should know that if you give out all the money to trust, the rest of the beneficiaries will now be in trouble, eh? So
Yes,
you have
ma'am.
to take advice. So even if you don't know, then you would seek advice, and you have powers that allow you to go outside and seek advice from professional advisors, eh? Yes?
Yes, ma'am.
Okay. Any other questions? Okay, let's go.
No, ma'am.
Each member of a trust committee should be aware of his responsibilities and duties regarding the trust, particularly the duty not place him in a position where his duty to the trust conflicts with his personal interests. If does not, it
So
does
it should say a duty not to place himself in a position where his duty to the trust conflicts with his personal interest. So it should be himself.
and then it should be it does not have a conflict. Well, if does have a conflict relating to his personal interest.
So it should, the duty not to place himself in a position where his duty to the trust conflicts with his personal interests.
Yes, and I'm trying to move on. And then it says
Okay,
if does,
if he does have a conflict
oh, if he
relating
does.
to his personal interests, right, they're missing out a few things.
If he does have a conflict relating to his personal interest, he must disclose this information to the trust committee and obtain the requisite consent or approval, if allowed or authorized by the trust instrument.
So
Trust committee,
when you have a conflict, you must disclose it, eh?
yes.
And then based on your disclosure, then the committee should make a decision as to whether or not they should proceed or they should go outside of this. So if it's going to be conflicting, then you have to.
Hello?
I think some on the computer.
Hello?
Okay, we can hear you now.
Yeah, we can
Okay,
name and
go
start it.
ahead. Oh, sorry. Okay,
That's
go
fine.
ahead. All right.
You were explaining. We didn't hear any of your explanation.
Oh, Lord, where we stopped. I thought I was just saying you couldn't hear me.
Yeah, we
No.
can hear
Okay,
you.
so
It cut out.
okay, so where I stopped.
We didn't really hear anything you said.
Okay, so we were on the conflict.
Yes, ma'am.
Yes, that they have a
Okay,
duty
so
to
I'm
disclose.
saying, right, so remember we said where the trustee's personal interest now conflicts with his duty, he must disclose this to the trustee committee before a decision is made as to whether the trust should proceed in that direction, because it can't be that, because they said in that instance, you're gonna put yourself first. So you must now put the client first, and then the trustee committee will decide whether or not they will proceed with that investment or move in that direction. Because once it's disclosed and they said, okay, that's fine, because it's disclosed, it's not going to be of any significance, then we'll move on. But if it's of significance, then they have to make another decision. So it has to be disclosed, because it can't be that you didn't say anything, because then what happens with what you would have gotten as a result of you being in conflict and you having the information as a trustee? What happens to what you get? If the beneficiaries find out?
You would be in breach. Hello?
Or whatever you derive as a result of your conflict.
Ms. Dorset, we're not hearing you. She really gone now.
I think our internet probably dropped.
We almost finished the chapter, so.
Yeah, the chapter short, so yeah, don't worry about that.
Okay, sorry, I have unstable connection this evening. You can hear me now?
Yes.
Sorry about that. Okay, I was asking, what happens with the trustee's benefit if he doesn't disclose the conflict and he now acts notwithstanding? What happens with his benefit?
It's confiscated, eh?
What we can call that? What happens? We suing you for what? With the benefit, if the beneficiaries find out, they sue you for what?
Breach?
Breach of trust, and now your assets become a part of the
Part of
trust assets
the trust.
as a result of operation of law. What that would be now?
A resulting trust.
So, or constructive, whatever you have.
Yes, ma'am.
Yes. You see, it now it's a constructive. You holding that as a constructive trustee for me, because you didn't disclose it, and now you would have gained an advantage as a result of you being the trustee. Go ahead. Any questions first?
No, ma'am.
Okay, let's go.
Trust committees must always act in the best interest of the trust and its beneficiaries, and may be required to seek the services of other financial institutions or service providers, where there may be a conflict in utilizing the services in-house, or where such service may be more competitive in relation to the investment, safekeeping, and management of trust assets. Members of trust committees may be required to provide individual reasons and explanations for their decisions, and are encouraged to raise concerns and objectives in the trust committee meetings as and when necessary. Trust committees are also entitled to seek advice or directions externally by delegating certain trust duties to agents. Example, attorneys, investment advisors, etc., subject to the provisions of the trust instrument. Trust committees are expected to consult the trust instrument, obtain research, and review the relevant information, make certain considerations of the facts under review, review trust accounts to determine the financial position of the trust, refer to the settlor's letter of wishes, and exercise their discretion within the ambient of the law and the terms of the trust instrument. In making distributions, trustee committees often consider the intention and wishes of the settlor, financial and special circumstances of the beneficiaries, and the long-term implication of distributions made to the beneficiaries.
So we're repeating now again what we said earlier. So you see how we keep repeating and expanding? This is now for reinforcement. So what they're supposed to do, consult the trust instrument, obtain, research, and review the relevant information, make considerations of the facts under review, look at the trust accounts, make sure the trust is in a financial position to make any distributions, refer to the settlor's letters of wishes, exercise their discretion within the ambit of the law and the terms of the trust instrument, because we have to always refer to that. And then we will, in making it, the distribution, we consider what the settlor wished for this beneficiary, what financial and special considerations or circumstances of the beneficiary. The beneficiary may be in dire straits, so this may be a special circumstance, so I may exercise my discretion based on the fact that if I don't help them, they will fall. And then the long-term implication of the distributions to the beneficiaries. How will this affect the trust as a result of me making this distribution? So I have to consider all of these things before I make a decision. And this will be demonstrated by what? How will I know you've done all of this? By what? As a trustee, what I'm going to see to know that you did all of this work.
The minutes?
Your deliberations will be in minute form. Okay? Go ahead.
Investment decisions made on behalf of the trust by trustee committees should be made upon consideration of the nature and assets of the trust, general economic conditions, the short and long-term needs of the trust and beneficiaries, and any express wishes of the settlors as applicable. The trustees are afforded certain protections under the provisions of the Trustee Act 1998 in exercise of their powers, particularly their discretionary powers. Section 30 of the Trustee Act 1998 protects trustees from legal liability for breach of trust occasioned by loss of trust assets, which may be caused by their agents, provided they appoint and supervise their agents responsibly and to the standard required by law.
So section 30 of the Trustee Act is another provision that they've now inserted that assists the trustee. So if there's a loss of trust assets as a result of me appointing an agent, or appointing an investment advisor, or I'm putting the trust assets in the hands of these investment advisors to increase the income of the trust. And there's some loss occasioned by the result as a result of me now employing these advisors. Section 30 protects me as long as I was doing my duty. I was supervising the agent's responsibility. I appointed them first responsibly, and I supervised them. So I didn't just throw the trust assets in their hand and not follow up to ensure to see how my income was what the returns were. How risky is the investment? Did I do all my research? Did I ask them the pertinent questions? So I shouldn't just be willy-nilly when I pass it over to them. I should ensure that I'm still acting responsibly and making sure that I manage the assets as if it were my own money. Because if you had your own money, you wouldn't just give it to someone and not follow up on it. So that's the same way they're looking at a trustee as a prudent man would in his own affairs. You should do the same thing. Okay. So section 30 gives us some protection once we're acting as a professional and prudent person would in the management and assets of the trust. Go ahead.
Additionally, trustees may be protected under the provisions of the Trustee Act 1998 if they make investments on the advice of a named investment advisor in the trust instrument, or one who has been selected and appointed based on consideration of the requisite knowledge, experience, and qualifications. All in all, the legal duties and responsibilities of the trustees and terms of the trust instrument must be of primary importance to the trustees in the administration of the trust, as well as the significance of acting in the best interest of the beneficiaries. These considerations are important to the discharge of any duties on the part of the Trustee Committee and in the proper functioning and governance of the Trustee Committee in the exercise of trustee discretion.
So all of the trustees' decisions and his responsibilities are primarily important in the administration of the trust. And he must always be acting in the best interest of the beneficiaries in discharging any one of his duties. It's important that the trust committee is a part of that decision-making process, and that one is appointed, and it's not made up of one person, but it should be at least 3 or more persons in exercising their discretion, right? Any questions? Okay, let's try to answer our questions at the back. Number 1, blank or inter vivos or testamentary trusts, where trustees have discretionary powers regarding which beneficiaries and what entitlements are to be received by beneficiaries in relation to the distribution of trust assets in accordance with the terms of the trust instrument. Where we'll find that answer?
Page 32, first
And
paragraph.
that is?
Discretionary trusts.
Excellent. From a seller's perspective, discretionary trusts are often created for the following reasons. What are they?
To provide for beneficiaries with special financial.
Okay, you have to tell me where I can find this now.
Okay. That's page 32.
Okay.
Page 34.
Okay.
That's the 5th paragraph.
Okay, and what they are?
To provide for beneficiaries with special financial, mental, and physical needs, to allow flexibility in adapting to changing circumstances of beneficiaries, for protection of trust assets from wastrel and spendthrift beneficiaries, and to make provisions for a wide range of beneficiaries, including those that may not be born.
Excellent. Number 3, the blank is clearly one of the most important certainties in the creation of discretionary trust, as the administration of such trust and the exercise of trustee powers within such trust require the clear determination of the beneficiaries or class of beneficiaries for whom the trust was created and may benefit. Where we'll find that answer?
On page 33.
Page 33. And what that is?
The certainty of objects.
Excellent. Number 4, the fiduciary powers contained in a trust have within them a duty to consider whether to distribute income or capital, but do not require blank. Where we'll find that?
Page 33, fourth
Mhm.
paragraph.
Mhm.
It-
And what is
but do
that?
not require that a trustee actually distribute such capital or income.
Excellent. So as much as they have a duty to consider whether to distribute it, they don't have to actually distribute it, eh? They could consider it and say, well, I'm not going to distribute it based on the circumstances. Number 5, if a trustee does not exercise his discretion prudently, blank of his fiduciary duties to the beneficiaries. Where we find that?
At the bottom of page 33,
Mhm.
if a trustee does not exercise his discretion prudently, he may be found in breach of trust of his fiduciary duties to the beneficiaries.
Excellent. Number 6, trust committees provide for the overall blank and blank of trust assets. Where we'll find that?
That's the second paragraph on page 34.
Mhm.
It's the overall stewardship and management.
Okay. Number 7, trust committees often decide the following in relation to the administration of the trust, subject to the terms of the trust. Where we'll find this?
That's also on page 34.
Mhm. And that's number
Uh,
1 to 10?
yes.
1 to 10. Number 8, trust committees must always act blank and may be required to seek the services of other financial institutions or service providers where there may be a conflict in utilizing the services in-house, or where such service may be more competitive in relation to the investment, safekeeping, and management of trust assets. Where we'll find that answer.
That's at the bottom of page 34.
Mhm.
It's in, trust committees must always act in the best interest of the trust and its beneficiaries.
Excellent. Number 9, blank of the Trustee Act 1998 protects trustees from legal liability for breach of trust occasioned by loss of trust assets, which may be caused by their agents, provided they appoint and supervise their agents responsibly and to the standard required by law. What is that?
Section 30
Section 30. Excellent. And where we'll find that?
on page 35
Okay.
on the fourth paragraph.
Okay. Number 10, trustees may be protected under the provisions of the Trustee Act 1998 if they make investments on the advice of a blank or one who has been selected and appointed based on consideration of the requisite blank, blank, and blank. We will find that answer.
That's also on page 35.
Mhm.
That's paragraph 5.
Okay.
And it's the advice of a named investment advisor
Uh-huh.
and as the requisite knowledge, experience, and qualifications.
Excellent. Okay. This was a short chapter, which was sweet, because I think we know this one back and front, eh?
Yes,
The
ma'am.
trustees' discretionary powers are what?
What's the question?
What are the trustees? We know the trustees' discretionary powers. What kind of powers, the discretionary powers, the trustee have? Danae, Joanne. They have wide powers, eh?
Yes, ma'am.
And responsibilities. And all their decisions must be made in the best interest of the beneficiary. What is the ambit and extent of the trustee's powers? We just said.
What is the question?
What is the ambit and extent of the trustee's powers? Determine the ambit and extent. We just answered.
Is it about the terms of the trust?
It's wide, eh?
Sorry. Yes, ma'am.
It's a wide ambit, and it extends what? What the extent of it is. At the end of the day, it is for what?
The best interest of the beneficiary.
Excellent. Okay, now we're getting somewhere. What are the fundamentals of the trust committee?
To make the decisions in the best interest of the trust.
Right. And so they should, how they should do it?
They have to vote.
How they doing this? How they can make decisions?
Through deliberation.
And how these deliberation, what their deliberations could be about? We repeat this, we keep reinforcing this. Tell me what it is.
You have to make a reference to the nature of the assets of the trust.
Right. So we'd have to first of all be a majority decision, eh?
Yes.
Yes.
And this trust committee should consist of what? How many members?
3 or more.
Excellent. And then in considering what they're doing, they should do what? Consult the
Investment advisor or an attorney, an agent.
No, let's start off with what they have to consider in making their decisions. They have to consult the what? What guides them?
The letter of wishes.
The trust instrument first. Then they have to review the information.
Mm-hmm.
What else they have to do?
Determine the financial position of the trust.
Awesome. So we getting somewhere. Now y'all know where we are. Go ahead.
Refer to the settlers' letters of wishes.
Uh-huh.
And exercise their discretion.
Within the
ambit of the law.
Right. So their ambit is within the law and the terms of
the trust instrument.
Excellent. You see, and then they considering what the settler wanted, if we can afford to do this now, because I may consider whether what may I do? I may consider whether to distribute income or capital, right? But do I have to distribute it?
Not if it's not in the best interest of the trust.
Right. So what case tells me I don't have to actually distribute it, notwithstanding I considered it?
Turner versus Turner.
Excellent, excellent. So when the legal principles underlying the exercise of the trustee's power, what are the legal principles? What section 30 tell me?
Section 30.
That you protect it protects the trustees from legal liability for breach of trust that may happen due to losses of investments.
Where they appoint agents, right?
Yeah.
Provided they've done what?
Supervised the agents.
Properly, right? And I should be within the ambit of the law at all times. And once I'm within the ambit of the law, done what I was supposed to do. In the case of investments, where there's a loss to the trust, where an agent is acting on behalf of the trust that I've appointed. Once I've properly appointed that agent and supervised them, I will not suffer any loss or be sued for breach of trust because Section 30 gives me some protection, right?
Yes.
So we have the trustees being protected, having a further layer of protection. And we now have how the trust committee should act and how they should deliberate and how it should be documented. And we know how they come to a decision and what they may consider when coming to a decision. Any questions on this chapter?
No, ma'am.
This one is clear as day or mud.
As
Good. Okay, so we have small little chapters. So unit 4 is going to be a quick one as well. So we'll be done in 2 seconds flat on Saturday.
That's all.
So just take a look over the information that I've already sent you, and that should be sufficient, and we'll move on to unit 4 on Saturday.
That's all.
Okay. I'll see if I find Turner, but I've already sent you McPhail. You all have that, right?
Yes, ma'am. We have it.
Okay, excellent. Okay, thank you for attending, and you all have a good evening.
All right, you
Thank
too.
you.
Okay, good night.